Hello guys, welcome to our channel Random Dictation. Subscribe our channel for more dictations on daily basis.
Start. The submission of the learned additional advocate general is primarily that since the husband of the writ petitioner was a work charge employee, the writ petitioner would not have been entitled to the benefit of dying in harness rules, but on misrepresentation of the writ petitioner that her husband was a permanent employee of the Public Works Department, the appointment was wrongly given to her, and on coming to know of the correct facts regarding her misrepresentation at the time of seeking appointment, her appointment as a permanent employee has been downgraded to that of a work charge employee, on which position the husband of the writ petitioner was working. Stop. Learned counsel for the appellants has relied on the full bench decision of this court in the case of Pawan Kumar Yadav versus State of UP within bracket 2010 for UPLBEC 2633 in support of his contention that a work charge employee would not be entitled to the benefit of the dying in harness rules. Stop. There is no dispute about such proposition, and we accept the said submission of the learned counsel for the appellants. Stop para. The contention of the learned counsel for the appellants in so far as it relates to the grant of appointment to a dependent of a work charge employee under the dying in harness rules is perfectly justified. Stop. A work charge employee who is not a permanent employee cannot be given the benefit of the dying in harness rules. Stop. However, as far as the present case is concerned, the writ petitioner had been granted appointment under the dying in harness rules way back on 24/4/1993, and it is presumed that the said appointment was given after verification of the documents which had been filed by the writ petitioner. Stop. After more than a decade, if it had come to the light of the appellants that the appointment was obtained by the writ petitioner on misrepresentation or fraud, that is, by wrongly showing her husband to be a permanent employee of the department instead of correctly placing his position as that of a work charge employee, the option which could have been available to the appellants would be that of cancellation of the appointment and not of downgrade the same from that of a permanent employee to a work charge employee. Stop para. We say so because appointment under the dying in harness rules can only be given to the dependent of a permanent employee and not to a dependent of a work charge employee or temporary employee. Stop. Once the appointment had been given, it is presumed that the writ petitioner had fulfilled all the conditions of grant of compassionate appointment under the dying in harness rules. Stop. Once the authorities have given such appointment to the writ petitioner, the same cannot be downgraded to that of a work charge or temporary employee on the ground that the initial appointment was incorrectly provided. Stop. If the writ petitioner was not entitled to the appointment under the dying in harness rules because of her husband being a work charge employee, the option available to the state was not to place her as a work charge employee. Stop.